Asylum Access Mexico, and I'm based in Mexico City. I would like to start by introducing our panelists. We have two presenters who are here representing the council, and the rest of our panelists, our speakers, who will be introduced by Lu Blanc. Our facilitators from the Global Strategic Litigation Council are Alejandra Macias, representing Asylum Access Mexico. She will be giving the closing remarks, and Lu Blanc Prieto, Executive Director of Refugiados Unidos, who will also introduce the panelists. Thank you for joining our session, and we hope there are no technical difficulties throughout. Thank you. Lu Blanc, over to you. Good morning. Can you hear me? I'm sorry if there is a bit of a delay because unfortunately I am in a remote location at the moment with not very stable connectivity, but it's truly a pleasure to be here. And I'm very happy to welcome you into this very important and special training that we're promoting on behalf of the Global Strategic Litigation Council. And I'll start by introducing who we are. It's wonderful for us as founding members and also the rest of the members of the Global Strategic Litigation Council to be here. For those of you who are not familiar with the work that the Council does, it was founded in 2021 to promote efforts made by civil society organizations seeking to protect refugees and migrants through advocacy and litigation. Today, the Council has over 275 counselors, refugee-led organizations, members of refugee-led organizations, other civil society organizations, and from the academia all around the world. The Council seeks to support its members in promoting knowledge exchange, identifying priorities, and implementing strategic litigation as well as legal defense. The Council has supported its members in several ways by providing strategies for litigation, as well as writing pleadings and other documents to submit to courts. They have also drafted amicus briefs to submit to courts all over the world. In 2023, the Council organized a series of regional face-to-face consultations, which served as wonderful space to exchange knowledge and collaborate. In these consultations, the Council identified new cases where it could offer its support. To date, they've been held in Eastern Africa, Central America, and South America and Caribbean. The Council has also started to organize training courses and workshops for capacity building, such as the workshop we've prepared for you today. We have organized this workshop thanks to the members of the Council, who are also members of civil society organizations and defenders who have always worked to promote human rights. Today, the Council counts as members, amongst its members, Refugiados Unidos and other organizations from South America. As I said before, we have organized workshops together, as well as other meeting spaces that have had a lot of participation in South America from many of the members, and we hope to continue promoting strategic litigation for all interested organizations in South America so that we can support population coming from Venezuela and other parts of the world. Additionally, we have also identified high-impact cases when it comes to strategic litigation, and in those cases, we have submitted interventions to the Colombian Constitutional Court, and we have made progress in several areas. The Council and Refugiados Unidos have become very important organizations for Colombia and the region. Next, I would like to introduce our speakers. We have Helen Kerwin with us. She's a legal official from the Center for Justice and International Law, CIJL, based in Washington, D.C. Helen manages a series of active cases in the Inter-American Court of Human Rights and the Inter-American Court of Human Rights in Colombia, Ecuador, United States, and the Caribbean, including overseeing cases about the rights of indigenous groups and migrants. She collaborates with the CIJL Project for Human Mobility in Central America and the United States, and she coordinates the Network for the Americas on Nationality and Statelessness. Before joining CIJL, Helen worked at the Institute for Women in Migration in Mexico City, as well as in the rapporteurship of the rights of migrants in the Inter-American Court of Human Rights. Helen studied law in the Texas University. And our second speaker for the day is Gabriela Oviedo. She's also a lawyer from the University of San Francisco in Quito, Ecuador, and she has a specialization on human rights. She has a master's degree from the Michigan Law School, where she was selected as a scholar of the Grocio Scholarship, recognizing her professional and academic excellence in 2019 and 2020. She currently coordinates the Human Mobility Project of the Center for Justice and International Law, CIJL. She has worked in several litigation cases, advocacy work, and international research on human rights, human mobility, as well as human rights in corporations. So thank you to both of our speakers. And I would now like to give the floor to them and back to Silvia as well. Thank you very much. On the contrary, thank you, Lublanc. We know that you're out in the field, so we know that's why you can't have your camera on, but we appreciate your introduction on behalf of the council. So without further ado, I would like to turn it over to our two speakers, Helen and Gabriela. Thank you very much. On the contrary, we would like to thank the Global Strategic Litigation Council for facilitating this workshop today. First, I would like to confirm that you can see my presentation and you can see me. Just let me know that everything's working. Yes, we can see you both and we can see the presentation. Okay, wonderful. Thank you. Okay, I saw that amongst our participants, we have a very good representation outside of the region of the Americas. So I imagine that there are many people following the presentation through translation. I know that this will be challenging because there's a lot of content that we want to share with you today, but I hope that everything comes across clearly and we will try to leave some space for questions and answers at the end. As was already said, the goal of today's presentation is to introduce the Inter-American human rights system from the perspective of litigation. So what to do if I want to present an individual petition to the Inter-American Commission or Court. The same thing, if I want to submit a claim for precautionary measures, what are the basic requirements? What do I need to know? So we will try to do this focusing specifically on human mobility by highlighting aspects that are specifically important for those of us who seek to protect people in human mobility. So just to give you an overview of the presentation, first we will introduce what the Inter-American system is, both the Commission and the court, and then we will talk about individual petitions and cases from the beginning to the end of the process. Thirdly, we will talk about precautionary and provisional measures. And next, I will turn it over to my co-panelist, Gabriela Oviedo, to discuss advisory opinions and other ways to have an impact or work with the Inter-American Court of Human Rights. I also want to highlight that the Center for Justice and International Law has many resources available. Some are only available in Spanish, but others will be soon translated into English. You can access our website, sigil.org, and the more specific case for the project about mobility in Mesoamerica, which is the one that you can see below, Sigil Movilidad en Mesoamérica. So what is the Inter-American Human Rights System? It is made up of two main organizations, the Inter-American Commission on Human Rights and the Inter-American Court of Human Rights. The former is located in Washington, D.C., and the latter in San Jose of Costa Rica. This is an autonomous body from the Organization of American States, the OAS, which is a political forum made up by 35 countries from the Americas. The IACHR, as the court is known, was created based on the charter of the OAS. So they are both the Commission and the Court based on the American Declaration and the American Convention on Human Rights. And together they serve as a cornerstone for the protection of human rights in the American continent. So if I want to submit a petition or a case to the Inter-American system, what are the rights that I can plead? And what are the treaties and conventions that can protect these rights? So as I said, this is all based on the American Convention on Human Rights, which protects a wide variety of rights, as you can see on screen. The right to life, to personal integrity, freedom of expression, rights of children, and for those of us working in human mobility, the right to nationality and the right to mobility and movement and residence. And that includes the prohibition of collective expulsion of aliens, for instance, amongst others. There are other specialized treaties at an inter-American level that are important to mention. There is a Convention on the Protection and Sanction against all violations against women's rights, the Belén do Pará Convention. There are others on torture, forced disappearance, racial discrimination, amongst others. It's worth mentioning that on an inter-American level, there is no treaty that specifies the protection of workers' rights. On a universal level, there is a treaty, a United Nations Convention, but on an inter-American level, there is no such document. That I think is worth mentioning. Something else regarding instruments and specific rights. For countries that have not ratified the American Convention or that do not admit the jurisdiction of the Inter-American Court of Human Rights, as is the case of the United States, Canada, and some countries in the Caribbean, what is the basic document? It's the American Declaration on the Rights and Duties of Human Beings. It's very similar to the Universal Declaration on Human Rights, also from 1948. In fact, the American Declaration was signed 6 months before the Universal Declaration. And finally, if you are building a case to present to the Inter-American system, you have to bear in mind that no provision can be interpreted in restrictive terms. What do I mean by this? If a country is a member to the Inter-American Commission, but also the Convention for Refugees or the Convention to Reduce Cases of Statelessness, or for migrant workers, or for racial discrimination, or any conventions like those, you cannot interpret the American Convention to restrict any of the rights held by other treaties. This is a basic principle of human rights for pro-person, but this is relevant because this means that we need to have a good understanding of the obligations of states internationally through treaties and conventions, not only inter-American treaties and conventions, but in general. So let's talk about the Inter-American Commission more specifically. As I said, this is an autonomous body of the OAS. The function is to promote and protect human rights across the region. And it does so through two main categories of functions. First, everything related to petitions, cases, and precautionary measures. So those are individual cases. And the second is everything regarding monitoring and technical cooperation. So public policy, monitoring, recommendations, promotions, etc. So this has to do with monitoring specific situations and countries on a more general level. And the Inter-American Commission is made up of 7 members, commissioners, who are selected by member states of the OAS. In fact, next week in Washington, D.C., the General Assembly will be held, and 4 of the 7 members will be elected members to the Commission to begin their term in 2024. It's a very important election because over half of the members of the Commission will be renewed. And what is the Inter-American Court? The court is the jurisdictional body. It is also born because of the Convention on Human Rights, the American Convention on Human Rights, and its goal is to interpret and protect that convention. It has an adjudicatory function to rule on cases, and advisory function to present opinions interpreting the obligations of states according to the convention. And it can also issue provisional measures, which we can also discuss later on. There are 7 judges in the court. They are also elected by member states. So, what if I want to submit a petition to the court? What are the basic requirements and what is the process? Without getting into a lot of detail, because we might not have time for that, I will try to describe this process. I will also focus more specifically on how the case begins, how it is submitted to the court. So basically how to access the system in the first few stages. And also because for countries that have not or do not recognize the jurisdiction of the court, the commission is the only instance where cases can be heard. So who can present the petition? Any individual or group of individuals, any NGO, and it could be in representation of third parties, not only for yourself. So if I want to submit a petition, what do I expect them to rule on? First, if there was indeed a violation against the human rights that are collected in one of the instruments we mentioned, so the declaration, the convention, or any other instruments, to cause damage to an individual or collective. Second, if those violations were committed if a state is responsible for them. How can this be determined? Responsibility can be direct. For instance, if a migrant is held in a detention center and it is tortured by a public official, that is a very direct way of finding responsibility. Second, if the state, in the face of acts committed by third parties, was negligent or supported the acts of those third parties. So, for instance, there are many cases in Colombia of massacres that were committed by paramilitary groups, but where it was proven that the state collaborated or at least neglected to act, and that also means that the state has responsibility. And thirdly, something that specifically focuses on migration, because I think it's relevant in many situations of human mobility, is the duty of prevention that every state has. What does this mean? The Inter-American Court has found that states have an obligation to prevent violations against human rights in the case of specific, well-known situations that put individuals at risk. So a very representative case is called Cottonfield v. Mexico. This is a case of femicides that took place in Ciudad Juarez in Mexico in the 90s and early 2000s, and the court ruled that in that context of a high rate of femicides with impunity, the pattern became clear and obvious, which led the state, or should have led the state, to introduce measures to protect these women. The failure to do so means there was a responsibility for the state. So it is not enough to say that the situation with migrants in a country is terrible. No, that is not enough. More content is required in terms of evidence about a particular place, a particular population group. But this theory of responsibility of states, I think, still has a lot of exploring to be done. So if there is a violation and the state is deemed responsible, what happens next? A series of recommendations are issued to the state to repair, to offer reparation to the victims and avoid the repetition of these acts. But there are a series of requirements for a case to be admissible in court, and a series of exceptions. I will go through this very generally, although each one of them is based on significant case law. There's a resource about admissibility. It's a thematic report that you can find amongst the resources of the court that talks about the case law behind these conditions or behind these requirements. So what does the court or the commission have to prove as a condition? First, that they have jurisdiction over the individual and in the time and place where the facts took place. So it's not only a matter of territorial jurisdiction, but also effective control, meaning that the state has effective control over the territory, even if it is outside of its geographical jurisdiction. Ratione loci, ratione materi, which means that there has jurisdiction over the matter, meaning that it is a case about human rights and human rights violation. Also, that there is no lis pendens, or that judgment has not been made in a different court, meaning that no UN committee, for instance, has made a decision, or that the court itself has not reached a judgment on the same case before, and characterization of the case. So it's a similar standard to prima facie. If the facts are proven, they could constitute a violation of human rights. That means that the substance of the case really does have to refer to a potential human rights violation. Something else that must be proven is that internal recourses or remedies inside a country have already been used. And there's also case law behind this, because what exactly is meant by legal internal or domestic legal remedies? First, that they are adequate to respond to the situation, and effective legal remedies, which means that they could lead to the result that is desired. So these are things that internally within a country would have to be considered. So in some cases, an adequate remedy could be a legal amparo or protection, a constitutional action to protect human rights within a country. In some cases, this has to do with serious violations such as forced disappearances, extrajudicial executions, and the adequate remedy would be a criminal investigation and potential court case that could lead to a sanction. So these are the legal remedies that first must be used up. So first, those resources or those remedies must be identified. Then the court analyzes if they were indeed adequate or effective, and if not, if there is an exception. And the exceptions you can see on screen. Exceptions are listed in the rules and regulations of the court. We could give an entire presentation on these exceptions, but I will name them very generally. One is if there is no rule of law or due process in that country to protect that right. Second, if the individual has not been able to access national legal remedies. And the third, which is perhaps the most common, is that there's unjustified delay in the decision being made. And this means usually at least a few years where no decision has been reached in the case of in a case. If that is the case, then it may be taken to the court. I would also like to stop here to say that the second of these exceptions, which is that the individual has been unable to access a legal remedy nationwide, is also particularly relevant for migration. Because we know, those of us who work on a daily basis with people in human mobility, that these individuals face severe obstacles, challenges that may be impossible to overcome in practice when it comes to access to justice. That could be in their country of origin, in countries of transit, or final destination. And the Inter-American Court has plenty of jurisprudence about this situation that migrants commonly go through, and the measures that the states should take to guarantee access to justice for migrants in the same way as nationals from a certain country or residents would have. So I think this is a clear area where that could be explored, and potentially where arguments could be presented to determine the admissibility of a case to the court system. So if indeed there are no more legal remedies nationally, or there are exceptions, then the case must be presented to the Commission 6 months after that is determined. If the period is longer than that, it would no longer be admissible either. Okay, so those are the requirements. Now, what is the process to submit a petition to the court? Once it is submitted, there is a first stage of initial analysis. This is something similar to a prima facie, where there is a preliminary interpretation to see if requirements or conditions are met by this case. If it seems like that is the case, then that petition is sent to the state, requiring a response from them. Then there's an opportunity to make any relevant additional observations, and the court will present a report on the admissibility of the case, which assesses the requirements that we previously discussed in the previous slide. So once the court decides on the admissibility of the case, it is accepted, it is admitted as a case. It is no longer considered a petition, but rather it becomes a case, and it is given a case number within the system. If it is considered inadmissible, then a report will also be issued by the Commission to explain why it was not admissible. So once that report is made, there's a second opportunity for the parties to submit any additional observations on the matter, and then the Commission creates a report on the substance, on the merits of the case. So they analyze the situation of human rights violation and they issue recommendations. If a country is not a member or does not accept the jurisdiction of the court, what happens is a very short period for dialogue and consultation between the parties, and the Commission issues the report, and they do an annual monitoring in its annual reports to see if the recommendations that they issued are being respected or are being followed. If the case merits going on to the court, then there's a next period of transition, and this is also for dialogue between the parties to see if it is possible to reach an agreement to meet the recommendations issued by the Commission. If that is the case, then the report on the merits issued by the Commission is made public and redress has been achieved. If that is not the case, then the case is sent to the court, which we'll discuss in the next slide. So from the moment a petition is sent to the state, at any moment, and a friendly solution can be looked for with the country. If there is no interest, and if the plaintiff does not follow up, sometimes the case can stay in archive, and there are some situations in which the Commission doesn't issue two separate reports, one on admissibility and one on the merits, but they issue a single report contemplating those two aspects. Next, if the case moves on to the court, then there's a stage for written proceedings where both cases present their pleadings. In the case of the plaintiffs, it is something called as requirements, evidence, and pleadings, also known as SAP. Then there's an opportunity for the state to present its counter pleadings. Then there's a public hearing. Once the public hearing is held, there's an opportunity for final written pleadings. Then the court makes its decision. It communicates the ruling to the two parties. It is made public. And if indeed human rights violations are determined, then the court will issue a judgment that they will then monitor to see if the solutions found are actually met. Judgments from the court are definitive, binding, and not subject to appeal for countries, for any state that is found guilty in a specific case. The state may require an interpretation of the judgment, but that simply is to clarify something that is misunderstood, but it does not change the ruling in any way. Through the judgment, inter-American standards are determined, so there's jurisprudence, and the court is in charge of supervising when there is a judgment that the states meet the conditions. So this could be through a written process or through supervisory hearings. Sometimes those can take place on site to see if the court orders were respected or not. This is a period that may last years, even decades. In fact, it's common for them to be very long processes. And what mechanisms of redress can the court order? The court is renowned worldwide because of its integrated mechanisms for redress. This is different to what happens in the European Court of Justice, for instance, which in the case of human rights violations, they order the economic compensation. But in the case of the Inter-American Court, they seek other forms of redress, sometimes overarching, innovative forms of redress that go beyond monetary compensation. So yes, they may include compensation, restitution, public acts to recognize the responsibility by public officials, rehabilitation, so medical or psychological treatment, and guarantees of no repetition. And this may include training to public officials. They may also include adopting other public policies or other standards, pieces of legislation to guarantee that the rights that were violated before will not be violated again. And of course, the obligation to investigate and, if responsibilities were determined, sanction people who were responsible nationally. At any moment, as I said, in the process before the commission and before the court, a friendly solution may be reached, an agreement may be reached by the parties involved. If you are interested, when we reach the Q&A part of the presentation, we can discuss this because I think I'm running out of time and we still have to talk about precautionary measures before I turn it over to Gabby. So let me talk about provisional and precautionary measures. What are precautionary measures? They are an expedite and preventative mechanisms to prevent irreparable damage from happening against individuals or against human rights, to guarantee that a situation that the Inter-American system has been made aware of does not become worse. And let me go back for this. Precautionary measures have a protective function. That means that the rights of individuals need to be protected. So someone who is being threatened, for instance, a human rights defender who is being threatened, so to protect that individual, to make sure that those threats do not hold true and that no harm is caused to this individual. And the precautionary measures also intend to protect legally, so offer legal protection for legal situations. So for instance, preventing a deportation that has been determined, or preventing execution in the case of the death penalty in the case of the United States, especially because most countries have abolished the death penalty. So what is needed in order to request a precautionary measure? They may be granted to an individual, a group of people, if that group of people is determined. And how can that group of people be determined to require this? If they are a part of a group that has been identified as vulnerable, such as an indigenous community, a human rights organization, or because of the place in which they are. So a precautionary measure in favor of people that are being held at a specific detention center. Protection measures can be required by any individuals or their legal counsels. The requirements are more flexible than what we saw before, but the Commission sometimes does need some guarantees that conditions are met. So what can a precautionary measure do? It may lead to the Commission offering a recommendation for countries to protect the rights of the individual in question. So, for instance, in cases of threats, to adopt security mechanisms, to investigate the origin of those threats, to deactivate the risk, or in cases of detention centers, maybe it has to do with improving the conditions of the detention center. These are just some examples. And provisional measures. Let me briefly discuss what they are. Precautionary measures and provisional measures have the same requirements, but the main difference between the two, and I think this is relevant for you, I think that precautionary measures are more relevant for you. Provisional measures are only for cases that are in trial in the court or that rulings have been made, but it is only the commission that can require the court to issue a provisional measure. So if it is not a case that is already in the system, then what you will be submitting to the commission is rather a precautionary measure and not a provisional measure. So what are the conditions that need to be met for a precautionary measures? They are issued in serious cases, and that means that there is a serious impact that an action or the lack of an action may have on a protected right. If there is a sense of urgency, meaning there's a risk or a threat that is imminent and that can be materialized, or that the damage has been growing in time or the risk has been growing in time, and that it's a risk of causing irreparable damage. By irreparable, we mean a threat to the person's life or integrity, but it can go beyond that. An interesting example is the precautionary measure that was issued for unaccompanied minors under the zero tolerance policy during the Trump administration. The rights at stake here had to do with the children's identity and their development, which are also irreparable harm that could be made to the children. There was a risk identified of irreparable damage that could be caused to these minors, and that is why the court issued that precautionary measure to protect them. It's also worth mentioning that CIJIL, the Center for Justice and International Law, has issued a practical guide about precautionary and provisional measures specifically for people in human mobility. It is currently only available in Spanish, but it will soon be made available in English as well, and we will be happy to share this with you. There are a lot of details about the requirements and the process if you wish to submit a claim for a precautionary measure. These are the fastest solutions that the Commission may reach, and by fast I mean it takes at least a few months before a response is given by the Commission. Of course, we would like these processes to be faster, especially in some urgent cases, but this is something to take into account, that it usually is a process that takes a few months. Precautionary measures and provisional measures have a prima facie standard. This means that it is not necessary to prove with a high level of evidence and detail, as is the case in a case taken before a court, the risk to the individual, but rather it follows the prima facie standard because the situation is judged of imminent risk. And thirdly, if you wish to present a claim for a precautionary measure, it is not necessary that all national legal remedies have been used up, as we said before. However, if there has been an attempt, if a claim has been made to the court locally, or a police report has been made in the country to try to find a solution, that is enough. there is not a requirement that you have finished up all the legal remedies that exist in a country. And this takes me to the next point that I consider very important, because I see this all the time when claims are presented to request a precautionary measure. It is not a place to present a plead against violations. The Commission will not investigate if a violation has occurred. It will not investigate if a human right violation has occurred. Instead, as I said, the standard is that there's a risk of irreparable damage, so harm could potentially happen, but this does not mean that it has already happened. So, okay, maybe we can also get into more details during the Q&A if you have questions about this. If you are requesting a precautionary measure, you suggest to the Commission those measures that the state might issue to mitigate that risk. So what would you like to see the state do if the precautionary measure was issued? And finally, that the rights that you're seeking to protect go beyond the right to life or the risk to your physical safety. Of course, these are the ones that are most commonly sought to be protected, but there could be others. And I will leave it at that and turn it over to my co-panelist, Gabby, to go on with the rest of the presentation. I'll be brief because I don't have that much time. Thank you, Helena. Could you please help me with the next slide? Okay, so besides the adjudicatory function, the court also has, as we said before, an advisory function, which means that they can offer interpretations of the American Convention on Human Rights or other similar treaties or instruments. And these opinions are important because in most countries of the continent, the judges of constitutional courts, Supreme Courts, or similar courts, they can control or see if conventions or international treaties are met. And that means that they do look at the interpretations of the Inter-American Commission. So they can also make use not only of rulings of the court, not only of court decisions, but also the advice of the Inter-American Court of Human Rights. They are considered to be just as legally binding as the Constitution. So these interpretations are very important because they become international treaties, and for national legislation, for national courts, that means that they have the higher authority. So this has had a significant impact locally in Ecuador, in Colombia, and in other countries. They have used the advice of the court for local interpretations of cases, and that's why the opinions of the court have a positive impact. There are 3 pending opinions of climate emergency and human rights, and they mention a connection between the climate emergency and human mobility. The limit to present amicus curiae is in August 18, 2023. One is about weapons and the effects on human rights. This was required by Mexico. And the third is about the right to protection. And again, the limit is also on the screen to receive amicus curiae. These opinions, the advice provided by the court, can have an impact, as we said, internationally in the Inter-American human rights system, both for the Commission and the court, but also nationally because of what constitutional courts have to analyze when analyzing a case. Amicus curiae are used by organizations, civil society organizations, in order to request an opinion by the Inter-American Court. And this, I think, is interesting for the cases that we are discussing of climate emergency and migration. They are usually submitted by third parties, and they present an opinion to the judge requiring for the court's interpretation. They have to be submitted via email, and they could be related to cases that are in court, but they must be submitted 15 days after the hearing has been held. There are other mechanisms in the commission that we also think is worth mentioning, because Helen mentioned the most common measures, but these roles that the Inter-American Commission also promote the protection of human rights. So on the one hand, there are obligations regarding monitoring of recommendations. So when the Commission issues a report, it then follows the recommendations that it has given. It also follows specific cases across the region. The monitoring functions of the court lead them to issue reports, sometimes focused on specific topics that are related to human rights protection in the region. And specifically, I believe that when the court monitors, they can then offer public opinions about the situation of human rights, for instance, regarding the end of Title 42 and the adoption of Title 8. Sometimes these opinions have a lot of socio-political power to for the state or for the government. The Commission may also do local visits. For that to happen, the state must invite the Commission. That's an important requirement. So, for instance, this year and last year, the Commission visited Honduras, and one of the cases or one of the issues that they had to observe was precisely irregular migration coming through Honduras. But they also may analyze other issues. The importance of an in-loco visit is that they can get a better understanding of a situation. They can assess on site, and from that they can offer recommendations to the states that they visit. Often in-loco visits can be general, which means that they are there to assess the situation of human rights in the country in general, but they may also be specific, for instance, to human mobility. These visits have been made to Mexico, for instance. I think in-loco visits are a good way to make it known if violations are happening in a country, maybe by showing them cases that are being litigated in the country. For instance, in Guatemala and in other countries, after in-loco visits, precautionary measures have been submitted by the Commission. So sometimes if the Commission can assess the situation through an in-loco visit, they can then offer other measures to monitor the situation. Next slide, please. There are thematic reports or country-based reports. This is also part of the monitoring function exercised by the Commission. And the goal is to talk about recommendations and obligations of the government considering human rights. So they can be on a particular topic area. So for instance, the impact of extractivism or internal forced displacement in the north of Central America, but they can also be about a specific country. They are usually annual reports about the situation of human rights in the region. Then there are also thematic hearings and other actions during session periods. So a thematic hearing could be about a general or regional situation. There can be hearings about a country, about a specific situation in a country, or it can be regional. What is happening with human mobility in Central America? There are working meetings which can be about a specific case or about a precautionary measure. And these hearings must be requested by civil society organizations, the state, or sometimes the commission itself can hold these hearings if it wants to do so. For instance, in the next period of session, when the commission will be holding one of these hearings on international cooperation and the impact that international cooperation has in human mobility. So, in fact, organizations can sign up to these hearings on the website, and you can also submit requirements. We have a guide in Sigil as well that explains how to do this. Then there are charters of Article 41, which I will talk about as well, which are advocacy requests that seek to promote cases that already exist, but also to give visibility to a regional situation. They are mechanisms that put pressure politically on governments. Civil society organizations use the Article 41 letters, which are very similar to pleadings presented in the universal human rights system, where they send information about issues of concern, and they are based on Article 41 of the American Convention on Human Rights. And what the Commission does in those letters about Article 41 is that they review the letters, they receive the information that civil society organizations submit to them, and then they do a written request for the country about which the letter was sent, and they request information about what is happening in those situations. The Article 41 letter, there are a series of requirements about the information that the state has to give, and all that information is not made public to the civil society. But what we have seen is that these letters can be faster and sometimes potentially more efficient because there's a very quick response. So sometimes in the case of urgent situations, this can work faster than a precautionary measure, which, as Helen said, the response could take several months. But sometimes the letters are used, Sigil uses this remedy if there's a situation of a family or an individual who is at risk of being deported. If we believe that the decision of the court might take months, sometimes sending a letter can be effective at the same time that you seek a precautionary measure or something like that, just in the hopes that they can communicate to the state more quickly. When we have sent Article 41 letters about collective deportations under Title 42, that allowed us to do advocacy, and sometimes there's a hearing that can be organized in the state, and other actions can follow from one of those letters. Eventually, the commission might also publish something. So these are advocacy actions that can be taken that could eventually have an impact on a case. Other resources that we have available, and this will be the end of our presentation, we have guidelines that Sigil has created. We can share them via email. We also have a website on human mobility, and there's a guide for human rights defenders. There's a guide on provisional and precautionary measures that outlines the requirements. Then about hearings and how to request a thematic hearing with the commission. There's a guide for in loco visits, and that's it. I think this is the end of our presentation. Thank you very much for your time. We tried to stick to the time that we had, but hopefully you could grasp all this information. Thank you, Gabi. Thank you, Helen. Now we will have some time for questions and answers. But before that, I would like to give the floor to Alejandra Macias, Executive Director of Asylum Access Mexico, for her closing remarks, and then we will have the opportunity for questions and answers. Thank you, Silvia. Thank you, Gabriela and Helen, for your presentation. I would like to remind those of you who are not familiar with the work that the Global Strategic Litigation Council does, that the goal of the Council is to promote the efforts of civil society organizations that seek to better protect refugees and people who have experienced forced migration or forced displacement. We do this through litigation and through advocacy work. The Council is made up of more than 275 lawyers, refugee leaders, and human rights defenders. They all work in different organizations. The Council is also made up of organizations and members of the academia from all over the world, and it seeks to support Council members in exchanging knowledge, identifying priorities, and establishing strategies for litigation. I would also like to mention that this webinar, the workshop that we have organized for you today, was organized by the Central America and Mexico regional groups that are part of the Global Strategic Litigation Council for Mexico, Central America, and the Caribbean. These groups were formed after discussion and a series of consultations held in Mexico and Colombia. These consultations took place in March this year, and those consultations allowed for individuals to identify problem areas, best practices when it comes to strategic litigation. And that is what has brought us here today to offer this workshop. We have some questions. I'll be reading them out loud. There are 3 sent by Jimena Suarez. The first one is: how accessible is the Commission for Migrants in practice, if you consider that these are people in human mobility, that there's a lot of pressure of authorities to keep them from reporting, and that many societies marginalize migrant people? That's the first question. I'll read the other 2 questions as well. Jimena also asks us what cases are currently being analyzed by the Commission about migration and human mobility. And thirdly, what are considered to present to the court for its advisory function for an opinion. Thank you. They are 3 very good questions. I will share some ideas, and then Gabi can complement whatever I say. Regarding the first question about how accessible the Commission is, I think the answer is within the question itself. I do agree that the obstacles for people in mobility are very difficult. Sometimes their situation is more difficult than for other groups. Of course, this does not mean that that is an absolute rule. There are many people in different circumstances with different levels of mobility, which may make it harder for them to follow a legal process and therefore to protect and seek the protection of their rights. But people in mobility, because they are in transit, because they travel from one country to another, and the evidence that they need to prove a case might not be in the country where they are, or because of their lack of knowledge sometimes of the legal remedies or their access to legal representation and legal proceedings. All of these obstacles make it difficult for someone in mobility to have access to justice. Undoubtedly, I think this is what you see in your work every day. I'm sure in the cases that you are presenting nationally and representing nationally and internationally. So yes, that is true. However, what I would say is what I said when I was talking about admissibility, which is that the Inter-American Court, when it comes to its advisory function, its opinion 2114, for instance, and other judgments such as Veleslor v. Panama, has considered quite in depth the facts of the disadvantage that migrants face. This is something that they have expressed in a series of evidence. For instance, Dominicans and Haitians who have been deported. In a case against the Dominican Republic, the court considered the difficulty of gathering evidence against a deportation that happened outside of a legal framework. So they did consider those difficulties when assessing whether there had been a violation of a right. So there is some jurisprudence about this. The court has taken that into account in elaborating some standards. There is a case from last year or 2 years ago called Roche Azaña versus Nicaragua. The Roche Azaña brothers are Ecuadorians who, while they were in transit in Nicaragua, subject to human rights violation in Nicaragua by the authorities. One was murdered and one was hurt, and he sought justice for many years against Nicaragua. And the court heard this case and they considered all of these situations in their decision: the lack of knowledge, the marginalization, and the impact that has when it comes to protecting their rights. So that leads to them recommending that the states offer better protection mechanisms. Of course, there is a lot of work to do for these mechanisms, for these measures to become a reality, for us to really see and understand what is necessary for these rights to be respected or to be protected. Currently, the Commission has other cases about human mobility. I mentioned Roche Azaña. There's another one called Carmichael Center versus Bahamas. This is a case about the detention of Haitians and Cubans in Bahamas in 1998, 1999, and it establishes a series of standards about detention of minors. Sigil is currently working also with some cases of children detained in an exit facility and one on unaccompanied minor. One is called Laura S. versus the United States, which is about the deportation of a woman who had been a victim of gender-based violence. But, of course, it is important to look over the reports that the court has made public, or to approach organizations if cases still don't have a report. So it's important to see what cases are being heard by the court, to learn more about those cases, because sometimes information is not so easily accessible. Now, regarding the next question about topics that could be relevant for the court's opinion, I would like to ask Gabby to answer. Okay. I would add perhaps that one of the challenges, and we have seen this in litigation when we think about how accessible the inter-American system is for migrants, for people in mobility, the problem is precisely for these people to have access while they are in transit, or when they are in a new country, how they can access the justice offered by the inter-American system. At the beginning, the process can be done online, and that offers an advantage. But at the same time, we've identified that many people who want to access that justice or those remedies have difficulty finding legal representatives in a new country, especially in some areas, or if they are coming back from their country, that can be difficult, I think. There are several examples about how to guarantee access to justice for people in human mobility. I think there's a dialogue about rethinking those spaces. And there are interesting efforts such as regional networks for public defenders, for instance, where the idea is to provide legal counsel to help people access. There are many ombudsman offices or defender offices, human rights organizations that can offer legal aid. But of course, the lack of access or, the historical discrimination that migrants experience, of course, are a challenge when it comes to access to justice and access to the inter-American system. Regarding the opinions, the advisory opinions, in fact, it is states, I think I forgot to say this, that ask the court for their opinion. So their opinion about an article or another. In our opinion, states have done this for two reasons. One, when they want a response that can help them justify a political decision. So for instance, Ecuador presented the case about legal protection in embassies for the Assange case, and another one is if the regional or historical context requires it. So for instance, the climate emergency. The climate emergency is being discussed regionally, not only locally. So countries such as Colombia and Chile have decided to request the court's opinion. So this is something that's promoted by the governments, by the states. And finally, about people in human mobility, there are two cases that I want to mention. One is about migration detention of minors, 11 children versus United States, and Laura S., which is two cases mentioned by Helen. That one is about gender-based violence as a cause for international protection in a process where someone was deported through an expedited process from the United States to Mexico, but there was a clear need for protection because of a threat of gender-based violence. So those two cases I do want to mention. Thank you, Helen and Gabriela, for your answers. We have 3 more questions, but before we move on to those questions, I would like to tell you on behalf of the Global Strategic Litigation Council that we would love for you to join if you still haven't joined our network, because if you do that, you can also join the regional groups that we offer. We have 3 working groups, one for Africa, Central America and Mexico, South America, and the Caribbean. And there is a group being formed for Europe after a consultation which will be held in September. And then there will be one for the Middle East and Southeast Asia. In the chat, I will be sharing a link as well as a form so that you can sign up to join us. There you can also ask for the council's support. Okay, now the next questions that we have are by anonymous participants. One of them says that for cases of legislative bills that could be very serious when it comes to human rights violations, if those laws were modified, what do you think is the best mechanism available in the inter-American system? And the person says that he or she is thinking about reform to the law of migration in Chile and other projects such as the possibility of restricting the right to protest in the region. Another question is, what do you think about hearings promoted by the court ex officio regarding political pressure or impact? Another question by Joel Spani is, do you know about non-refoulement cases litigated before the Commission, where a deportation of a rejected asylum seeker was prevented through such a submission, and maybe the potential granting of precautionary measure? And if a case like that exists, which country did it concern? So I'll give you some time to answer these two questions, and then we can move on to the next ones that we have. Okay, I can start about the first question of what to do when there are projects to reform legislation that could lead to serious effects. For instance, the case of Chile and about the reform to the law about migration. So a clear example is if we identify that these legislative changes will lead to deportation or to causing an irreparable harm, then a precautionary measure could be requested, and eventually they could become provisional measures as well. But another part of a strategy could be to request a thematic hearing or perhaps an in-loco visit to Chile or Peru to see what the situation is like for people who are in between the two borders, and maybe, of course, the state would have to accept the in-loco visit. And alternatively, a letter for Article 41. So what I mean to say is that when a legal reform is planned, it's a variety of strategies that should be presented. It's not only one thing that you should be looking for. So yes, the precautionary measure could give a solution to one specific case if someone's life is at risk. But if you're thinking that there's a structural problem because we're talking about a legal reform, then all those other actions could be done at the same time. So requesting a thematic hearing, sending an Article 41 letter, or trying to promote an in-loco visit to a country, documenting a petition, something like that. So a series of actions instead of just one thing, I think could be more useful or more efficient as a response in a case like this to prevent the reform from being passed and to prevent the restriction of rights. Sometimes what happens is that there are several actions being done in parallel. So there is a constitutional amparo being promoted locally, but at the same time, internationally, you promote a case in the court. So you use at the same time the national court system, of course, if circumstances allow you to do so, and you look for the Inter-American system or other international systems if they were at your disposal. And another of the question is if there are cases of climate refugees in the region. No, there are no cases of climate refugees recognized as such in the region. There have been interesting efforts, and we know that a lot of documentation is happening in the region. But I would say that both the advisory opinion is an option, but I also think that the Inter-American Commission can come out with a report on maybe an interpretation of the Cartagena Declaration or other mechanisms that can allow a pronouncement on climate mobility. So I know that there are discussions, but there are no specific cases as such. The only one recognized worldwide is Joan Hay Liotta of the Human Rights Commission of New Zealand. So this allows us some example to see how people can be protected if they have been in mobility because of the climate emergency. Helen, I don't know if you want to answer the other questions. Thank you, Gabi. Yes, let me see. I think Gabi's answer about how to do advocacy, especially in the case of a legal reform, is very clear. There are multiple actions that one needs to promote. I would only add that it's important to work both on a national level, so doing advocacy locally at a national level, and perhaps I would prioritize working with the commission, and maybe not through an individual petition, but rather through an advisory opinion, because it's difficult to find a case that could be ready, that could be admissible if we're talking about changes to legislation. If it's only a bill in a Congress that's being discussed, then it takes a longer time. So the same thing happens with precautionary measures or petitions. You would need to take a specific case with a clear situation happening, and if it's a project, then it will be very difficult to have that, to present a case against public policies or against projects to reform a law. The Commission does not consider precautionary measures to be ideal for that. Regarding non-refoulement cases, this is a very interesting topic. Let me see. If regarding cases that the court has ruled, there's one about Haitians versus the United States from the 1990s. There's John Doe v. Canada. That is also a case that the Commission decided on a little over 10 years ago about the safe third-party agreement between Canada and the United States. This is a very interesting case, and there are some aspects about the agreement that are not covered in the case, but there are interesting observations about what is admissible or not when it comes to human immobility and their access to international protection. A more recent case, and the report was published about this, is Jamel Amessian v. United States. This is a man from Algeria who was detained in Guantanamo for over 10 years. So he didn't seek international protection, but when it became clear that he could no longer be detained, because it was an arbitrary detention from the beginning, he had pleadings that were justified about the fear of going back to his country. So this is very interesting. So these are some situations, not all. Regarding precautionary measures, I would like to point you to the guideline that we have about human mobility specifically. It has an interesting attachment that collects the main precautionary measures that the Commission has issued, and the criteria that they use to reach those measures. So about non-refoulement specifically, there are several decisions. I think maybe I would mention 2 or 3 recent ones. One about the United States from 2016. EGS and AGSG about the United States, and DS about the United States. They are both on asylum seekers, and in both cases it was from El Salvador, and they were cases that were expedited, and they were non-refoulement cases. In both cases, if I remember correctly, because I wasn't there and Jill was also not involved in the litigation. What I understand is that those precautionary measures did have an impact with the Salvadorian government, and they did not accept the refoulement of those individuals, at least for some time. Maybe there are other people who are more familiar with this case who can provide more information about it. And another one is one called 6 Migrant Children from Trinidad and Tobago from 2020. And this is a case of 6 Venezuelan children who reached Trinidad as unaccompanied minors. And again, there was a need to prevent their deportation. So some interesting standards were issued about this. As I said in our guide, there's a lot of information about this. And it includes other things such as extradition, internal displacement, and other topics regarding human mobility. And I would leave it at that because we unfortunately have run out of time. Thank you, Helen, and thank you, Gabriela. I know that you have to go, and I don't think we have more questions. So simply to wrap our discussion, I would like to remind you that in the chat we have the Global Strategic Litigation Council's link where you can see all the information. If you believe that the council can offer support, we would be happy to support you in several different ways. It could be through research by expert statements, strategic planning, and interventions such as amicus curiae briefs. And I would also like to mention that we are working with 2 organizations from Argentina on planning of documents. There is an organization in Kenya about experts on nationality and other cases of interventions about the rights of refugees. In the Colombian Constitutional Court, there is a case about the cancellation of nationalities for 40,000 Colombian Venezuelans. The council is promoting documents about this, and in Mexico, there are courts about human rights violations, and especially after the decisions made by the United States. We don't have any more questions and we have run out of time, so I would simply like to thank the panelists and the Global Strategic Litigation Council for organizing this webinar, as well as all of our participants. Thank you for your attendance. Have a great day.
Muchas gracias. Gracias de nuevo a Helen y a Gabriela.
Thank you, and thank you, Helen and Gabriela, once again. Have a wonderful day.
Thank you so much, Faith.